25 years actually puts me a little younger than I am. I'm actually closer to 30 now. So that is something to improve on our firm's biography site. Another little task. The presentation I put together, which I understand you guys may not have yet, the first page really kind of goes through my background, so you can see all of that you want. At the bottom, though, it talks about typical clients, and the only reason I put that there was to give you an idea of the diversity of kind of what the environmental practice is for me, only to give you, so you just kind of understand I've kind of been all the way around the environmental block, so to speak. Most of the time, I would imagine everybody in the audience thinks of environmental lawyers as being pretty specialized, and I would be for probably what the vast things that you guys probably see. However, in terms of being an environmental lawyer, I'm actually pretty general because I work in air, water, waste, environmental justice. I'm mostly regulatory, but I also litigate, and we're really just kind of across the board. Tons of transactional work because of the firm I'm at, which is McAfee and Taft, and we do tons and tons of transaction work. And inevitably, there's an environmental aspect to that. So I've seen a lot in 30 years. Okay, so we'll move on. Whenever Beth Ann approached me about this, I promptly did not put it on my calendar, as she was alluding to earlier. It's been a festive week for me, in part because of the little tornado that hit Barnstall, went right across one of my larger facilities. And I've been dealing with the National Response Center all week and DEQ and the local responders, which hopefully you guys never have to do because of the sort of large number of chemicals they have on site and the way they were containing them. It's all under control, but it's been a week. So if I appear a little frazzled, it's only because I am. So, okay, fair enough. Anyway, Beth Ann asked me to kind of talk about the kind of things that municipalities might face. So I've tried to tailor my items down to that. The first thing I've got is a list of agencies that you could hear from while just conducting normal, what I would imagine are municipal operations. Probably not all of you will face this, but I think some of you may face all of these at some time. Obviously, the big ones for environmental stuff are going to be the United States Environmental Protection Agency, or EPA, the Department of Environmental Quality. Those two probably handle the vast majority of what I think municipalities would see because they're responsible for water issues and water permitting, and that's both drinking water supply and wastewater discharge and treatment. So those are the kind of, I think, the two you would be dealing with most of the time. However, if you're going to have asbestos removals in either your own buildings, or if you have a condemnation or something along those lines that you have to take a building down because it's a hazard to the community, there are some environmental laws around asbestos that might apply there. That would be DEQ and the Department of Labor on that one. You have the Oklahoma Corporation Commission might be involved if you're operating USTs for fuel for your vehicles. If you have enough need that you would have a USTs or an above ground storage tank, that's going to be under the jurisdiction of the Corporation Commission. If you are running a water supply system and you have to cross a stream or a river that's a regulated body of water, then you are also going to be dealing with the Army Corps of Engineers in order to be able to cross streams. And again, I'm just trying to imagine things that you guys might see as municipalities and what you might run into. The last one I'll do, and that's if you have water discharge or some other chemical store and somehow or another it gets loose in a way that you have a fish kill or a mussel kill or something into a stream that you're discharging into, then you might also, you might see some of the other, you might see EPA, DEQ again, but you might also see the United States Fish and Wildlife Service, as well as the Oklahoma Department of Wildlife Conservation. Those two aren't in the presentation. The final two I put in there, I added those this morning, so I will have an updated presentation that they can upload after this, sometime later, probably Monday, actually. Okay. So that was kind of the agencies I think you could run into or be involved with or need to deal with. And if you are dealing with those agencies, that might be the time that you would want to seek out someone like me. The next thing I want to talk about will be environmental programs under those agencies, kind of specifically. And I want to start with the Clean Air Act. I imagine most municipalities are not operating incinerators anymore. I know some used to. Anybody in the audience have an incinerator for their municipality? No. Okay. So that's good because those are difficult. Pretty extensive regulations are for operating municipal waste combustors. And that's probably why a lot of the municipalities got out of the business about mid-90s. But that was something, if there was someone, we could talk about that. The other thing under the Air Act are a couple things that aren't obvious. Asbestos and lead-based paint both fall under the Clean Air Act. I think personally that the air group at EPA lost the coin flip when that happened, or drew the short straw, however you want to say it. It really kind of, in my mind, fits more under the waste program, but it is under the air program. And with asbestos, it's only really a concern whenever it becomes airborne, can become breathable. So that's probably why it landed under air. Lead-based paint's a little harder. It's really a hazard when someone, I mean, it's bad if you breathe it, if it gets ground up and you breathe it, but it's also bad if it gets chipped off and you consume it, particularly if you're a child. So the asbestos and lead-based paint stuff, that could come into play on your own buildings. If you have older buildings or boilers, they may have asbestos, you may have lead-based paint. I often see lead-based paint on handrails, oddly enough. So it finds its way, and most asbestos and lead-based paint stopped being used in this country in the mid-70s. But EPA, as late as this year, was still finding products to get asbestos out of that are coming into the states. I don't think lead-based paint is a problem anymore. But if you have an older structure, that also works. Again, if you're condemning something and taking it down, if it's a nuisance and you need to take it down as a safety mechanism, you want to watch out for asbestos and lead-based paint. Questions there? Anybody ever had an asbestos inspector show up on site? Okay, that's good. Another situation that I think falls under the Air Act that might affect you guys, it's kind of a blend between waste and air, is open burning. Sorry about that. Can you guys hear me? Okay. Open burning, I'm gonna say it now because we're in storm season. At times, the DEQ has had to relax the open burning regs because of the need to have municipalities and areas be able to use open burning because of just the vast amount of waste, construction debris, that becomes a part. Can anybody hear the beeping? Is that this or? No, it's my phone or my watch. Thanks. That was going to bother me. Sorry about that. So open burning can be a thing at times. And just as a note, if there is ever a major amount of storm debris that as a municipality you're dealing with, it may be possible to get some relief in terms of being able to burn it openly, but you'd have to work with DEQ to do that. So just as a footnote during storm season. Okay, the last one's going to be a little bit more esoteric, but I'm going to mention it because it's getting ready to be a problem in the state. There is a thing called non-attainment with the Clean Air Act. The Clean Air Act sets national ambient air quality standards for a bunch of different pollutants, including ozone. So if you've ever seen ozone season, whenever you're coming into Tulsa or Oklahoma City and they have ozone alert days, that's trying to get people to use their cars less, so we create less ground level ozone. Ozone's created by nitrogen oxides and volatile organic compounds mixing at our level. Ozone's good 3 miles up, bad down here. The problem with that is we're about to be non-attainment most likely in Tulsa and Oklahoma City. That won't stop at their border. It will reach out further. and the various air pathways. So if you're in a municipality around one of those two bigger locations, non-attainment is coming, most likely. We'll see. We won't really know till the end of this season, but it's a possibility that it's going to be a thing. Non-attainment, what it practically means is we're going to have more rules and regulations about what companies can do and come in. If it gets really, if we're deemed to be really severe, we might have to cut back on the permits of some of the larger air permits in and around those municipalities, or that might affect the airshed that it has that. And lastly, if we don't do that as a state and as communities, eventually that starts affecting your ability to get highway funding. So it's a big deal. We haven't had to deal with it in this state really much at all. The last time we had active non-attainment was in Tulsa in the late 80s into the early 90s. We were able to put rules in place that got that back under control, and we went into what's known as maintenance for it at that time, and we've been there ever since. The rules, let's talk just a little bit. I'm going to step and I'll tie this together. The environmental rules that were put in place when EPA was formed in 1970 were built around science. And science, it was brilliant at the time, because where do you really start with setting a standard when you never had one before? So they took the scientific studies they had and they tried to work that into things like the ambient air for nitrogen oxides and volatile organic compounds that create ground level ozone. They came up with where it should be. Well, as science progresses, those statutes demand that the regulations be revised to account for new science. So as they figure out more that ground level ozone and what it does to people and how it impacts their health, the standard gets lowered. And that's what's going on and why we're going to be non-attainment, because they've recently lowered the standard down where we probably just will not be able to easily reach it anymore. So anyway, that's coming. There was something to keep an eye on. Hopefully we're able to avoid it, but I don't like our chances. We'll see. Questions on that? No. Okay.
What degree is the electric beating before we get back to that?
It's going to help. Unfortunately, combustion engines are at their worst when they're in traffic, stopped, or when you start them up in the morning. That's when most of your emissions occur from them. They get much better as they get warmed up and as they're moving normally. It should help. Is it going to help fast enough? I don't know, but it may help us on the backside where we can go back to maintenance if enough as the fleet transitions to that. Does that make sense? Yeah, I think it'll help. It's also going to, the more of the power plants convert away from coal and gas to solar and wind, that will also help. But again, it's just not going to happen overnight. So we'll see, but it might help us down the road jump back out of it. Okay. Next one that I think you guys could deal with is the Resource Conservation and Recovery Act, which is the federal rule that sets sort of the baseline for all of the solid waste and hazardous waste regulations. Again, that's a DEQ and EPA thing, like the Clean Air Act is. The one I think that it would be biggest is if there used to be municipal landfills that were run by the municipalities. If you have one of those, then you're probably already really familiar with RCRA. If you're not, or you're thinking about having one of those, RCRA will be a thing for you. It's very complicated. The rules are tough. It's almost impossible to put a landfill in at this point in time. If you have an existing landfill, however, it is much easier, at least possible, to add on to it and create new cells to kind of keep it moving. It's very hard to start a new one, though, just based on how the rules have changed over the years. The other place more likely you'd run into it is if you're operating waste transfer stations. Same set of rules in a lot of ways, lots and lots of regs on where you can put them. Can't be in floodplains, can't be over alluvial soil deposits, which are, think of it as sand. There's lots of things that come into play when you're trying to place a waste transfer station. If you've got an operating one that you didn't have to deal with that, it's probably because you're grandfathered in. So you may be able to stay that way. That's one of the places I think you could see. Just chemical storage or disposal. If you have chemical stores as part of your municipal operations, there are regs on how you store those, particularly whenever it becomes waste, how you get it picked up, where it goes. All of that can be very important. And then you guys may or may not deal with illegal dumping. That some of those rules also are derived out of that. That's really probably going to be more of a DEQ thing, at least outside of your city limits. But I would imagine you deal with it some anyway. That's a place where the solid waste rules can become a thing for you guys. Clean Water Act's the next thing, and it's probably are you any of your municipalities running wastewater treatment? Yeah. So that's a tough one, and it's getting ready to get a lot tougher. You already have stormwater. If you've got water supply, that's kind of defined. I don't know that it's changing as much yet, but wastewater and publicly owned treatment works, or POTWs, EPA has been, and I'll just say this now, it's impossible to have an environmental conversation anymore without mentioning PFAS. So if you haven't heard of PFAS and you're getting ready to hear other environmental things, your news aggregators are going to be talking about it probably extensively. PFAS is, and I'm going to probably say this wrong, per and polyfluoroalkyl substances. They're known as the forever chemicals. They're amazingly wonderful at the things they do. They're in a lot of fire retardant foams. You'll find them in Gore-Tex. So if you're wearing a Gore-Tex lined shoe today, you've got PFAS in your shoes. Could be in your jackets. It's all over the place, and it's been with us for a long time. It's throughout the entire environment. EPA has been waving its saber for a while that it's going to issue restrictions on wastewater discharge that will account and make us handle PFAS out of that. This year, they have started releasing things that, like a new testing method was approved early in January, and then 2 months ago, EPA published notice of a pending request for information to the POTWs. Only the really big ones across the country are going to get it, so you may or may not get that. I'm going to say this right now. If you get one of those letters from EPA, you need to call someone like me. It doesn't have to be me, but call someone like me, because they do not have that program under control yet. We don't have good ways to capture PFAS. We have a very severe standard that is going to be placed on that, and it's hard to know where you can even take it if you do capture it. They're trying to get the cart way ahead of the horse because it's such a big deal for certain parties, and it's going to create a lot of just operational and compliance problems to start with. So if you have wastewater treatment, get ready for PFAS. Questions on that? Okay. Okay. The next thing I want to talk about is kind of the obvious things that I work on day in, day out, and things that you guys might run into. I mentioned earlier, my practice is primarily regulatory. I deal in air, water, waste, and environmental justice all the time. I help people with permitting actions all the time. That includes applications. So if you know you need let's say you're going to put in wastewater treatment, you're going to have a permit to do that and to operate it. If you're going to have water supply, you have to have a permit to do that and operate. I help people with those permitting actions quite a bit. You're going to have a consultant involved in that too that's going to do the technical stuff. I'm not going to be running the calculator, but there are other things where the consultants and the lawyers should be involved in permit applications in the environmental realm. When you submit a permit application, you've spent some time getting together. This is what our operation is. This is what we think the chemicals are that are regulated. This is how we're going to handle them. This is how it fits into the state's permitting regime. You submit that into the state, and they oftentimes will look and say, yeah, you got a lot of it right, but you might get what's known as a notice of deficiency. A notice of deficiency is not a bad thing. It just means that they've got to understand something better, or they need more information in order to process your application. Notice of deficiencies are common when you're doing permitting. It shouldn't be a thing to get worked up over necessarily. It's just something that has to be dealt with. One of the things you can do before you ever put in a permit application, if you want to understand what you're going to have, is seek an applicability determination. Help on a lot of those. Those are oftentimes more, you're kind of thinking outside of the box and you don't know precisely what you're going to do. So you're asking questions on what it might look like. That's a very useful tool if you're going to be in the permitting regime, is to be able to use applicability determinations to either say, this is the kind of permit we're going to need, or we don't need one at all, maybe in some cases. So useful tool to understand and be aware of. When you are regulated, whether you have a permit or you should have a permit, if you get inspected, then they might find problems. They will walk around, they'll ask a bunch of questions. They may send you requests by email thereafter. They will probably show up unannounced. It's almost always at the most inconvenient time of your week possible when they show up, just almost a guarantee. And, what I like to tell people to do in inspections, if they can, is be courteous. If you have safety protocols they have to go through before you can take them into your operational areas, and make them do that. They are not exempt from having to go through safety protocols. If they don't like that, then call hopefully your operations people will call the city attorneys, you guys, I presume, and tell them that they have to do that. How do inspections start? Well, sometimes inspections you're just on a list for EPA or DEQ, and they're just working through their list. They keep a list of everybody that should have permits or that kind of fit profiles. The other way you can start though is when you get a complaint. So you've got someone that's driving down the road. They're maybe don't have an axe to grind, maybe they do, but there's a 1-800 hotline number at DEQ that they can call if they see something they don't understand. Give you an example. My facility in Barnsdall, they had to set up an emergency flare this week. They got a lot of calls from people in Barnsdall saying, what is the smoke? That place is on fire. What's going on? It wasn't a problem. It was actually a helpful thing. But complaints happen, and they come in, and the people don't have to give their names. It can be anonymous. There's nothing wrong with that. But that's also how inspections get started sometimes. And those are usually a little bit more frantic because there wasn't really a plan. It's the agency being reactive when they show up at your site. And they're trying to just understand what's going on and see what needs to happen. So you just have to work with them whenever that happens. Questions on any of that? Nope. Other ways compliance evaluations can start is whenever you, as a municipality or an entity, decide that you want to do an internal audit on yourself to understand if you're complying. This is a very, very helpful process. So if you have some questions, or the law's changed, or you think the law is changing, you want to understand, you can run an internal audit to say, okay, here's what we are doing. Here's what we need to look at. We're fine there, or we need to change this. Those are super helpful. If you're going to do that kind of audit, you want to do it under attorney privilege. So if your operations people are going to do that kind of thing, make sure you get it under privilege. You can always let the privilege go if you need to submit stuff, but it's helpful to have if you do find a problem and you're trying to decide how to handle it. We do lots and lots of work helping companies or municipalities do internal audits. In the event you do find a problem as you're doing your internal audit, there's a process known as a self-report or a self-disclosure. Highly recommend using this if you found a problem. That allows the agency to not beat you up as bad if they have something that otherwise fits their enforcement criteria. It always helps their mood whenever they find you come to them and have explained the situation, explain what you found, explain what you're doing to fix it. That's always the way to start that process instead of having them come out and find it themselves. Similarly, a few years back, we passed as a state what's known as an Environmental Audit Act. If you want to not handle this only as an internal audit, but you want to go under the protections available under an audit process, you can fit under DEQ's Environmental Audit Act requirement. That works for air, water, waste, probably laboratory services too, if you wanted to, if you're running a lab. It sort of takes the benefits out of DEQ's hands. It guarantees your privileges and it guarantees your protections in terms of enforcement. So that is a super helpful act. The act is based on Texas's act, which has been in place for about 30 years. So we already had a good idea of what it was going to look like and how it would run. And DEQ, to their credit, called Texas Commission on Environmental Quality and figured out a lot of the shortcuts. So they're really already pretty much up to speed on it, way faster than Texas was able to get there. That is a super helpful process if you have let's say you have a big turnover of employees and you don't maybe trust what was going on with your wastewater operations. That might be a good time to do an environmental audit and to sort of confirm things are good. Okay. Kind of the last piece of that puzzle is if you found problems and you're going to have to implement corrective measures, oftentimes those corrective measures will require their own permitting. So you might have to, if you found something, okay, we're going to have to add this process or add this, even a change of chemicals or the number of hours you're operating something a week or a day or a month. That might require changes to your permit. So that'd be something to look at. May not require an entirely new permit. It may be a permit modification, or it might require a new permit. Just depends on what you find. Okay. The type of enforcement that inspections normally are is civil. And if they've done an inspection and they found problems, the paper they usually send is called a notice of violation or an NOV. Can be really problematic. Can be when you get if and when you get an NOV, one thing to understand is the agency might have gotten it wrong. So you need to look at things closely. They may have gotten it right, but they could have gotten it wrong. And oftentimes they do because they're not going to understand your operations as well as your operations people will. They understand what they want to see, but there may be more than one way to comply with the law too. So when you get one of those, it's not the time again to throw your hands in the air and panic. It's more dig in and understand. Notice of violations have kind of specific time frames with them on how the agency has to respond and how you have to respond. They're often statutory. What they do now, part of the time, instead of sending you what's known as the NOV document, they will send what's known as an alternative enforcement letter. It will look exactly like an NOV without saying NOV on it. And when doesn't say NOV, you're outside of those time frames. It gives everybody more flexibility. So whenever you get one of those, the agency may think they're going to need more time or that you're going to need a lot of time to work on whatever it is. It's the same thinking. I mean, again, that could be wrong, but it's just you got to dig in and look at it and understand what you're getting into. Probably a good time to look for a specialist like an environmental lawyer, certainly consultants if you're doing wastewater treatment, those kind of things. One of the other documents you can get from an agency is called a request for information or an RFI. Those happen for a couple of reasons. One is, like I mentioned earlier on PFAS, EPA is getting ready to send a request for information out for a lot of the working POTWs. They're doing that because they want to know how to write their rule. So they're going to see what the information comes back and what's been found at these larger POTWs that's going to get these letters. That's just the first wave. Everybody will eventually do something. That's one of the main reasons they would use a request for information is to try to understand what the whole scale of operations across the country are doing in a particular thing that they intend to regulate through a rule. So that'll be, once you see that going out to that big group of POTWs, you know rulemaking's coming right behind it or somewhere. Could be a year, could be 3 years. Who knows how long it'll take, but it's coming. In the event you had an NOB and you actually had a problem that had to be resolved, the way the agency, again, I expect it'll be DEQ most of the time for this group, the way the agency handles it, and they want to handle it, is through a device called a consent order. It's a settlement agreement. It's their kind of multi-purpose document that allows them to resolve things. Consent orders oftentimes have a really negative connotation to them, but they can be super helpful. It's you have the ability, whenever it's a consent order, it implies both ways. You've got the ability to negotiate a bit on what the wording is going to be. You've got the ability to set schedules and that sort of thing. If, for whatever reason, they don't go the consent order and you get something called a compliance order, that's one-sided. That's them telling you what you will do and on the time frame you will do it. And they will have very strong stipulated penalties associated with it. Hopefully you land in the consent order range if you ever have an NOB and not a compliance order. Both of them can have penalties associated with it. I will tell you that I'm sure the agency does not like beating up on municipalities. They probably don't want to any more than they have to, but sometimes they're going to feel like they have to. Kind of a little secret about that is sometimes if you've got a particularly interesting noncompliance, DEQ is the primary agency in the state for most of the things you will do. I've mentioned that already, but EPA always holds concurrent jurisdiction. It is always better to settle with DEQ than EPA. I mean, very few instances I've ever seen that it was better to go to EPA than DEQ. They're local. They're us. They don't want to beat up people, and particularly not municipalities. But they sometimes feel like they have to. And if it was a bad enough issue that they're trying to get corrected, then you really want to settle with them so you can keep EPA from coming in over the top of them. So it needs to be an appropriate settlement. And sometimes it might be helpful to, I don't know why my alarm keeps going off. Sometimes it can be helpful to settle with them just to keep EPA out of your business. So, little trick of the trade there. All of that's been civil we've talked about so far. Investigation can also fall in the criminal side. I've done quite a few of them at this point over the years. They're always super intense when they get started. People want to be figured out on criminal stuff as quickly as possible. I get it. They also can start through inspections. It can start through a complaint or a whistleblower. And there likewise will be evaluations and corrective measures that will maybe have to curb again. Again, same thing. If you get a subpoena on one of those sort of things, I mean, again, highly good time to get someone that understands environmental law. But it doesn't mean they're right. And whistleblowers oftentimes get it wrong. But it does happen. If you run in wastewater treatment, if you got chemical stores, that's where I think whistleblowers might become a thing for this group. It's more of an issue on I think the business entities than would be for you guys, but it is a thing. I've had to go through a few grand juries now with some clients, and they're no fun. We've mentioned rulemaking a time or two, kind of on a separate side. That's the other place I think you guys probably need to be watching a little bit. Obviously, the PFAS examples is going to come, and the whole area for PFAS should be watching. So rulemaking happens at the federal and state level. Oftentimes, the federal government issues the first rule, and then the state simply adopts it or incorporates it by reference. That is certainly what happens in the air world, and I think it still mostly happens in water. But they may write their own regs at times to sort of get the same job done as the federal rule was doing, and you just have to watch to see which way they're going to go. I don't always understand the rhyme or reason. Air at this point is almost entirely incorporation by reference. They don't change the federal rules very much because there have been too many of them. There have been in excess of we're on the the 7th round through the alphabet on one of the programs. So I think we're in the we may be over 500 new rules since the mid-90s in the air program. It's quite challenging to stay on top of it all. Litigation. Don't do a lot of litigation. We don't do a lot of environmental litigation in this state. Really not a whole lot in this region. They do a lot more of it on the coast. But it does happen in this region. I've got a client right now that is involved in a Superfund litigation down in Muskogee. And do you guys ever have opportunity to buy new property? Yep. Whenever you're going to buy property, you always want to do a phase one before you buy the property. When you do a phase one, you get what's known as the affirmative defenses that go with the phase one. And they're basically innocent purchaser defenses, which is to say we did our phase one, and let's say it didn't show there was any problems, but when you get the property, it has some problems. That phase one, those affirmative defenses can be presented if whatever it is you bought becomes a Superfund site. Pretty unlikely. Doesn't happen very often. Did in Muskogee, though. My client happened to have finished a phase one before they purchased a piece of property that was then in a Superfund. The plaintiff on that side that brought it was not the EPA. It was the company that sold them the land. And they sued my client for contamination on a site they said was clean, lawfully under Superfund. And they kept us in it until we worked an order separately with EPA. It was a very horrible situation for my client. Everyone knew they hadn't done anything wrong, but because they owned on this Superfund parcel, it was a problem. And the plaintiff did not want to accept our phase one affirmative defenses, but ultimately that's what won the day. And we got I was told was the only innocent purchaser settlement agreement that's ever been issued by the EPA. Because usually people don't sue those. This plaintiff was particularly pathetic. So it does happen. If you're going to buy property, you must do a phase one before you close on it. Every time. That will give you the protections you need. And whenever you do your phase one, you want to make sure it's under the most recent standard, which came out in 21. And you want to make sure it says these words, all appropriate inquiry. It's in the presentation that you get. If you ever go seek a phase one, they have to be able to give you all appropriate inquiry. You do that, you get it before you close, you're going to have the affirmative defenses available to you. Questions on that? Okay. Let's say you have to condemn a piece of property. That also can be problematic. It might be hard to do a phase one, but I don't know if you could or you couldn't. I don't know why you couldn't. I would do a phase one before I condemn property too. I would pay. Phase one's going to cost you $2,500 to $5,000. It's the cheapest insurance going. I mean, I know that probably sounds like a lot, but it's way cheaper than being stuck with the $120 million Superfund verdict, which is what they were facing in Muskogee. So if I can tell you one thing today, phase one with all appropriate inquiry, do that every time before you buy property. Okay. Litigation, like I said, didn't happen very often. I had this particularly big one that we just finished up in Muskogee. They were a state entity. They're not a municipality, but they're an industrial authority, essentially. But they are a state entity, so they were kind of in you guys' realm. Litigation, again, doesn't happen much in this area. When you're going to have it, it's probably really going to be more administrative in nature rather than in front of the courts. That means you've got a permit, you're asking for a permit, someone's wanting to fight you on it, doesn't want you to have it. There are some mechanisms within the federal rules and the state rules that they have adopted that allow people to request administrative permit hearing. Those are held before an administrative law judge. The law judge makes his decision, and then the director of the agency will agree with it or not. You get a final agency action. And at the end of that, If the parties still want to keep litigating, then you can move into district court. But you might have to go through the administrative process first. Most of the litigation I handle is at that administrative level and doesn't make it to the district court. It does happen occasionally. If it's going to be a Superfund suit like the one that was in Muskogee, that starts in federal court. So that's those are unusual, though. Probably we'll never have to face one of those. All right, I'm finishing 9 minutes and 43 seconds early. Any questions? All right. Okay. Yes, ma'am.
I mean, I know they go on private property that sure about making like the survey can not.
Yeah, if you can get access to do a survey, you can certainly do a phase one. Phase one is not drilling.
They're sticking, land, rocket need with railway get on.
How would you get on to do the survey if you?
He does much well. Surveyors, already.
I'm not familiar with that, but if someone is.
It's our that is new. Anyone. They got it there.
To do the phase one, they do have to walk the property.
It's I think if you do these on the trespass, area. And they you can't get risk. See? Understand. They do what? They control. They do keep.
How is the do we know how surveyor is defined? Because in a sense, phase one is an environmental survey. I don't know if it's general enough to fit under that or not, but if you're doing a phase one, you have to be able to walk the property.
There's no drilling?
None.
No, it's like
phase twos are where you'll see drilling. Yeah. But the protection's attached to the phase one. So
right.
The phase one may suggest that you do a phase two, depending on what they find as they're doing their desktop surveys, which is, they go, when you do a phase one, they ask for, they put a dot in the middle of the property you're talking about, and they have a circle that extends out, and they look at all of the environmental things that have been filed through the various federal processes. So have there been gas stations with underground storage tanks within a half mile? Yep, you're going to find out. And it'll say all these things. Well, depending on what they come back and they see and the way the slope of the land is, so if all that stuff is sort of uphill from the property in question, then they'll be worried that it could have migrated onto that site. And so they might say, we want a phase two or recommend a phase two.
They need it with all costs from they need the pay on the name going.
No, they have to walk the property. Yep. They don't have to drill, though. You never have drilling in a phase one. Yep. Yes, sir.
Just like no, they're the policy piece of gold. After piece, they
has to be, usually it's owner or operator. And I don't, on an easement holder, I'd assume you're talking about the operator if they were going to be liable. I assume on an easement situation, it would be the operator side that would be subject to liability if there was going to be.
Apply it away.
Yeah. I've never actually had to answer that question. But again, it's liability is almost always in owner-operator terms. So, if you own the property that the easement's granted on, you're in the chain if it's a Superfund or a surplus situation. But if you're the operator that was working under the easement, that might also draw you in. Now you might have some defenses that all I did was put down, a pipeline, and it wouldn't have been the type of contamination you guys are talking about. But if you exasperated contamination that was in the easement while you're putting in your pipeline, then you might be on the hook. Does that make sense? Yep. Anyone else? All right. Thank you so much. But my contact info's on there. If you guys think of questions after this, because I know I kind of had to rush through this. If you think of questions after, just give me a call. Happy to talk about it.
Yes.